Kathy?
Yes.
It's up.
Okay.
See it.
All right. The court called the case of Roderick Walker, which is on our calendar this morning. And before we go on the record, I guess my question is, do we need to go on the record? Mr. Butterfield?
I believe this is going to be a consent, Your Honor, so I have no objection to however the court wants to proceed, Your Honor, for our announcement on this matter.
Okay, and it would be a consent as to the probation matter?
That is correct, Your Honor.
Okay, and Mr. Daly is handling this for the state?
Correct, Your Honor.
That's correct, Your Honor. Good morning.
Okay, we do have a consent on it?
That is correct, Your Honor. I believe that we spoke briefly before you took the bench, and I believe Mr. Butterfield, along with the state, would consent to continue on probation at this time.
Okay. All right, so do we need to put this on the record? Y'all tell me. If you're gonna send consent, I mean, we have Officer Dixon on here as well.
Yes, Your Honor, we can put it on the record.
Ms. Ingram, you ready?
I am. Judge the record button.
Okay.
Good morning, Your Honor.
There you go.
All right, this is the state of Georgia versus Roderick Walker. This is 17 SC 149682. The court, today is Tuesday, September the 29th, 2020. I am in courtroom 8A. Our courtroom is open to the public. Staff by a member of the Sheriff's Department. We are also on the court's YouTube live stream channel. And the matter appears on our defendant appearance waived calendar. The defendant, Mr. Walker, is not present, I don't believe. Is that correct? He's certainly not present personally. I don't think he's on the Zoom call. Is that correct, Mr. Butterfield?
That is correct, Your Honor.
And before we get into the question of whether he waives his appearance and go any further, I believe that both the defense and the state have announced to the court that they have reached a consent on any probation revocation. Is that correct, Mr. Butterfield?
That is correct, Your Honor.
Is that correct, Mr. Daly?
That is correct, Your Honor. And I would note, Mr. Butterfield, I believe he started telling you this as well, but Mr. Walker is not present this morning because he is in compliance with his probation. He is doing some classes related to that probation. And so the state has no problem with him waiving his attendance so long as the court doesn't.
Okay. No, absolutely not. And Mr. Butterfield, does your client in fact waive his appearance to be present this morning?
He does, Your Honor. I spoke with them this morning. And if I can just briefly tell the court a little bit about what happened since being released on bond with the consent bond in this matter. I reported with him on last Friday on 9/25/20 to the probation department, and we met with Chief Charles Kennedy. And right now we went over the fact that the warrant was lifted and that Mr. Walker, he was not in compliance because he did not have a change of address. We did that a week prior, so his new address is listed with probation. In addition, he is currently taking the parenting class today. There are going to be 8 classes, and it's with active parenting classes, and it's via Zoom right now. In addition, he's already signed up for the anger management classes on 10/1/20. There are 8 classes with Atlanta Anger Management that have already been paid for. So since being released on bond on his matters, he's had all of his medical appointments with ophthalmologists. He's seen a neurologist. He's seen an orthopedic doctor, as well as some therapists in this matter. So we've been, since he's been released, continuously getting him to various treatment providers, but also on the probation matter, we believe now he is in active compliance with that, just trying to finish up all of the terms and conditions, Your Honor.
All right, so the agreement then is to leave him on his probation in the 17 SC case. And who is Officer Dixon? Are you going to prepare that paperwork?
Yes, Your Honor, I am.
I appreciate that.
Good
And
morning.
if you'll get that to me, I'll note that it's a consent and I'll get that signed and entered. Is there anything further we need to discuss about?
No. Give it here. Give me the
No.
ball.
Nothing from the defense, Your Honor.
Put the top on there.
Nothing on behalf of the state.
Okay.
On probation.
And at this point, I'm going to conclude this case and thank you all very much. And Mr. Butterfield, if you have nothing further, you're welcome to sign off. Mr. Daly, do I get to keep you?
You get to keep me for one more matter, Judge.
All right. Thank you very much, Your Honor. Have a great day.
Thank you, Mr. Butterfield. All right, thank you. Ms. Hawkins, how are we doing on Mr. Thomas?
I just got off the phone with him. He was logging on. I don't see him
Well,
yet.
there is somebody who just came on who I muted because Mony Hart. If that is he, I'm happy to unmute, but let's go ahead and call the next couple of cases. Number 14 and 15 are Terry Michael Darian. Period. Hi, Ms. Borsick, how are you?
Good morning, Judge Barwick. Nice to see you. I've got two devices plugged in because I had some speaker issues. Are you able to hear me?
I can.
Wonderful. Thank you. Good morning. Your Honor, we're here this morning on our request to modify and terminate the probation in this case, which is almost a decade old. And we'll be prepared to move forward when you're ready for us.
Okay, who's going to represent the state on this?
That is me, Your Honor. State's ready.
Okay, let me call the last case and then see where we are. Number 16 is Cortez Simmons.
That's my client, Judge. Ms. McCauley and I are very close to a negotiated plea on that case, but I do think we need a little more time, maybe a week.
No, Kat, let's put it on for as soon as possible. I'm not married to that specific charge in your email. We can come up with a resolution. That's
Today.
yeah, I don't know if we'll be able to get a hold of Mr. Simmons today. I know I did talk to Mrs. Simmons over the weekend and sent her the Zoom link. So if they're here, that would be great. If not, we can maybe try for Thursday to get them on.
Judge, I talked to Mr. Simmons yesterday. I know Your Honor is eager to get it resolved before the end of the month. If we could have a few minutes for me and Ms. McCauley to talk, maybe I could get him back on in an hour.
I want to, let me ask if Mr. Simmons is on the line. I have unmuted everybody that I muted just because we couldn't hear, and that's Anila Jefferson and Mony Hart. And there's some other people muted, but I think they've muted themselves. So is Mr. Simmons on the Zoom call? Let's start with that. Anybody here for Mr. Simmons? Okay, you want to reset it for a week or a month or what?
Judge, would you, how invested are you in getting it taken care of today? I think that
y'all are doing, I'm so proud of y'all. I want you to have the freedom to resolve these cases, which you're doing a very good job doing.
I think we can, I think we have a negotiated plea at this point. If we could put it down Thursday or a week from today, I think we can go ahead and get it done.
Kathy, can we do that?
Yes, I'll
Okay.
put it on Thursday.
Okay.
Okay. All right. That is the end of the calendar.
Judge, we have number 17. There's one more page.
Yes, Judge, and if we could just hold for Adam Abadi, I think he's going to be handling that matter this morning.
Okay.
I've reached out to him and I'm actually forwarding him the Zoom link now.
Okay.
Um,
Apologize. I did not, I didn't see that one initially. So this is Ms. Samantha Gardner. This is a CP case. So am I hearing it because y'all are just doing a great job getting cases before the court, or was this a presiding matter that was handled by Judge LaGrua?
This is the presiding.
Your Honor, I believe what happened in this case, I'm Amy Hayes. I'm sorry, I'm one of the counsel for Ms. Gardner. I believe what happened in this case initially is it was set down to be your case for the initial bond hearing because of another high profile bond hearing that happened on the same day as the first hearing. It got moved over to Judge LaGrua's calendar. And so, but for some reason, and I'm not really sure how it works in Fulton County, but now it's back on yours. But I do know that the co-defendant was also handled by Judge LaGrua. But we're more than happy to be here and in front of you, so.
Well, that's very kind. Welcome. And Judge LaGrua did handle that, my presiding bond calendar, purely out of collegiality, which I very much appreciated. So this is my case.
Yes, ma'am.
I will handle Ms. Gardner whenever we get to it. So.
And Judge, it's going to be actually Grant Rood, and he is attempting to sign on now. I think he'll be with us in just a few moments.
Okay, and I do have some letters. So I'm going to go ahead and take up Ms. Borsick's case if somebody's ready on that, which is the reduction of probation. Is that it, Ms. Borsick?
Yes, Your Honor.
Your Honor, briefly, if I may, my co-counsel is on, Ms. Nicole Jones. I do need to switch over to another matter real quick in Paulding, but I will be back momentarily. If not, she's more than capable of taking my place and doing all of it on her own.
Okay.
Thank you.
All right, Ms. White is sharing her screen with us.
I don't know why, Adrien, why are you doing that?
But come on, you can do better than that, Ms. White. We can, don't you have pet pictures?
Sorry. I was trying to
Pet pictures.
show two screens at once. I didn't mean to share it.
We are always glad to hear from you, Ms. White. But if you could take us off that feature, we're going to go ahead and start the Darien matter. And I don't know how I'm pronouncing that, but this is Samantha, you ready?
Yes, I am.
Okay, this is the state of Georgia versus Terry Michael
Derone.
Derone. Okay, and this is 10 SC 97010. This is on for a motion to modify the defendant's probation, I believe. Today is September 29th, 2020. I am in courtroom 8A. Our courtroom is public and staffed by a member of the Sheriff's Department. Staffed by a member of the Sheriff's Department, and we are also on the court's YouTube live stream channel. So we are satisfying our obligation to make certain that the public's business remains open and accessible to the public. The defendant is represented by Ms. Lynn Borsick, and Mr. Jeremy Daly is representing the state. And is Mr. Derone present?
He is, Your Honor. I see him directly underneath me on the screen, but I'm not quite sure how your screen appears. I do see Mr. Derone present, and I've spoken with him this morning. I see him on the screen as we speak, Your Honor.
Okay, Mr. Daly, are there any questions you would like to ask of Mr. Derone regarding his waiver of his physical appearance in court before we get started?
Yes, Your Honor.
Started.
Mr. Derone, do you understand that you have the right to have this proceeding in an open courtroom at a later date?
Yeah, and I'm perfectly okay with.
I
A
could
little
barely.
hard to hear you, Mr. Derone.
I'm sorry, you do not hear me now?
Yes, really speak up. The sound is a little bit down.
Okay. Mr. Daly, I do not have any problem with proceeding with the Zoom meeting.
And you fully discussed all that with your attorney.
Yes.
All right, state satisfied. We're ready to proceed.
All right, Ms. Borson?
Thank you, Your Honor. Your Honor, this case was in court it was a 2010 case. It came before Judge Baxter in March of 2011. I represented Mr. Terry Derone at that time. And at that time, he was sentenced to probation on this matter. The case was handled by Mrs. Sally Butler, who was the director of the division at that time. And we entered into, Ms. Butler had a very extensive set of special conditions of probation designed for this sort of a case. This was a possession of child pornography matter. There were never any allegations of child molestation. There were never allegations of any attempts to reach out to children. The evidence in the case was that Mr. Derone had looked at numerous photographs. And we entered into probation March 30th, 2020. So 9.5 years ago from today's date. The terms and conditions of probation were stringent, and Mr. Derone has worked steadfastly over the past 9.5 years and has satisfied each and every one of those terms and conditions. First and foremost amongst those conditions was counseling through the Highland Institute. That was Dr. Jean Abel's institute, which Your Honor likely remembers. And Mr. Derone's counselor at the institute was Candace Osborne, very highly regarded therapist. She is on our telephone call today if Your Honor should wish to speak with her. She's written a letter for you. We filed all of these motions much earlier in the year, Your Honor, before COVID hit, and then COVID hit and really shut everything down. So you'll notice in the documents that this has been in progress for some time. We have a letter from the Highland Institute from last September, so a year ago today, and I sent that to Your Honor last week as well as to Ms. Kelsey Jones, so I hope that Mr. Daly has it as well.
I've received it.
Thank you, sir. Dr. Osborne states that that Mr. Derone has completed has worked carefully through all the different aspects of the therapeutic process, which is quite intense. He's also been subjected to annual polygraph tests, and he has taken those and he has passed all of those. I submitted the most recent polygraph test for Your Honor and also provided it to the district attorney's office. As a part of this process, there is a screening that's done by the Sexual Offender Registration Review Board. And I thought that that might be significant to you in analyzing whether or not it was appropriate to terminate Mr. Derone from probation at this time. The Sexual Offender Registration Review Board reviewed Terry Derone, and they found him to be at the lowest level of risk. They rated him as pardon me?
Hello? Someone else talking whom I've muted. I'm sorry.
Okay. No problem. They rated him as a level 1 low sex offense risk. In speaking with Ms. Osborne last week in preparation for the hearing, she shared with me that persons who only whose only offense is the viewing of child pornography have extremely low risks of reoffending. She stated it at 3% or less. And he has done very hard work and very open work, meaning an opening up of himself and an openness to really addressing the underlying issues that that led to him looking at these materials, There was a inappropriate touching against him when he was a young person. And that is the underlying issue to his looking at the photographs. I reached out, Your Honor, to probation officer Angela Price and asked her for a letter to the court and for Miss Connor Jones regarding Mr. Durone's compliance with probation. And we have that letter with us, and it states that Mr. Durone is in full compliance with all conditions of probations. She has placed him on administrative non-reporting probation since August of 2018. She tells the court that he has not received any new offenses while under probation supervision. And she reports that the Highland Institute, Ms. Candace Osborne, has reported back to her that there's been full compliance with the sex offender treatment sessions. He's paid all fines and fees and does not owe any funds on probation. Those documents are all with both with Mr. Daly and Your Honor. The last item that I prepared for you were just some cases where other courts have contemplated whether or not it's appropriate to terminate probation, and in a review of what they had done. And so I noted 4 cases for you and for Mr. Daly. The first is a case out of the U.S. District Court for the Northern District of Georgia. Defendant is John Christian. It was a 2011 case. That person was sentenced to 40 months in prison, followed by 10 years, 120 months of supervised release. After 6 years of supervised release, the U.S. Attorney's Office entered into a consent agreement with the defense for early termination of that probation. The next case was a Gwinnett County case. The defendant's name was John Holstein. It was a 2010 case. As this one is, he was sentenced in 2011, as we were in this one. There was an early motion for termination of probation at 6 years. We did not do that in this case. We waited until 9.5 years to ask. That order was denied at 6 years. They reapplied after 9 years, and it was granted. The next case is also a U.S. District Court, a Northern District of Georgia court. Defendant's name is Dwight LeMasters. It was a 2008 case, and he was given 5 years in jail, followed by a lifetime of probation. After 8 years, he filed for a motion to terminate or reduce his probation. They call it supervised release in the federal system, and it was granted after the service of 8 years in the federal court. And the last case was a Fulton County case. It was a 20 years of probation entered in 2000. He filed a motion to terminate probation in 2014, and it was granted that same year. I thought it might be helpful to have sort of a ballpark of what has happened in other cases.
I'm in the courtroom.
Mr. Durone has carefully abided by all these conditions, and the conditions aren't just the probation. Every time he wishes to leave the state, he must go and check in at the police station at the destination. So for instance, his sister lives in Colorado. To go visit his family in Colorado, he must register at the police station in Colorado when he arrives, and he must go in and see them again when he leaves. He has to get a permit to leave the state. He is, every quarter, the sheriff comes to his home to verify his residence. Every year on his birthday, he goes to the sheriff's department and has a mugshot taken, fingerprints taken, paperwork updated. They need to know what vehicles he drives, what work he is doing, what his telephone numbers. He's not allowed to have antivirus software on his computer. So he has to manually run some sort of virus check on his computer every day of the year. It impacts in ways that we might not even anticipate. And of course, there are financial aspects of continuing to see a therapist and continuing to have polygraph exams. I can't imagine a person doing better on probation than this.
Can I just ask you, Ms. Borsick, a couple of things?
Please.
Number one, how much longer does he have on his probation? I'm sensing that the file is under seal. Is that correct? Because I can't see anything on Odyssey.
You know, it was a first offender, and I
Okay.
wonder if that's why. So
Your
it's an
Honor,
in- Oh,
I'm
go
sorry
ahead.
to interrupt. If I
Mr.
may, Odyssey is not working this morning, so I can see it, but I can't open any documents.
Yeah,
So I
Mark.
think that's the issue.
Okay.
Would it be helpful for me to send you?
No, what I was asking, and I just wanted to preface my comments because I'm by telling you that I can't find out what I'm about to ask you. How much longer does he have on his probation?
Okay, it's a good question, and I'd like to show you the documents.
Is
So
it a question? The answer?
There are two indictments.
Okay.
Both a plea entered into on the same date, that date being
I can answer that, Your Honor.
March 30th, 2011. The first case says 5 years, all counts to run concurrent. The second case says 10 years, all counts to run concurrent, but to follow indictment, the one that said 5 years, which
So he
is,
has about 5 years left?
there's some confusion in my mind about whether or not these are concurrent with each other because the word consecutive is never used. However, I want to be fully candid with the court. You can't see this. It says the words, but to follow indictment, the other indictment. So it's not
Excuse
precisely.
me for a minute, Ms. Borsick. Officer Dixon, how much longer does he have left?
Yes, Your Honor. He has 6 months and 1 day remaining on this sentence. His expiration date is March 29th, 2021.
Okay, and Mr. Will he remain subject to reporting as a sex offender? Whether he's on probation or not?
Officer Dixon, I'm sorry, you can go ahead.
No, I'm sorry. She was asking.
I'm in the courtroom.
Does that guy keep getting off me? Okay, come on, somebody tell me.
To
Does he have to-
answer the court's question, Your Honor, yes, he remains on the sex offender registry.
Yeah, I agree, Your Honor. I think he has to keep registering regardless of whether he's on probation or not.
Judge, you're muted.
We muted somebody.
Yeah, me.
Mute. That's pretty good. Okay. Does Mr. Daly, does the state oppose the termination of the probation early so long as he has to continue registering?
Well, I guess that is a good question because my understanding, and I got sent the final dispositions. It does say as to the indictment ending in 010 that it's 10 years, all count to run concurrent, but to follow indictment ending in 067. So my understanding is he did have 15 years probation. And I don't know if that was just documented incorrectly by somebody previously to this hearing, but I'm looking at the final disposition sheets. And I don't know why it would say, but to follow indictment number, if it didn't mean that it was consecutive sentence.
Okay, so Officer Dixon, you think he has 6 months left?
Well, I'm showing in our system, Your Honor, that it says his expiration date is March 29th of 2021. So that's what I have in my system based on.
Okay, so there's some confusion across the board here then on how much longer he has. If we look at the sentence, it sounds like it's consecutive probation has it down as 10 years. What do we want?
Your Honor, it's showing that because the 067 ended March 29th of 2016. So I show him only on this case.
And I just, again, Your Honor, and obviously I've seen orders that have come out of Judge Baxter's courtroom previously in handling these cases. I mean, I'm reading directly from the disposition on the 010 case. It says 10 years, all counts to run concurrent, but to follow indictment number 10 SC 97067. And so I don't think it was the intention of the court at the time to run both of the cases concurrent with one another. I don't really agree with, I guess, with Ms. Borsick's interpretation of that meaning. It seems to me that was added specifically so that it would run consecutive to the other case. I would agree with probation that the other case is over.
Sorry?
I'm sorry, Your Honor. I would agree, generally speaking, that the 5 years has run on the 067 case.
Okay.
But
so let's say that he's got 5 more years of probation. Just let's hypothetically say he's got 5 more years of probation. What are you asking, Ms. Borsick? You're asking me to just chop off that 5 years. 1/3 of his probation.
Your Honor, he has been on non-reporting probation now since 2018. He has fully complied with every single term and has done the treatment. He has done everything. I think he has satisfied the terms and conditions, and I think the real concern was getting through the treatment. And he did that for years and did it successfully. I believe he is at a point where he should be terminated from probation.
Okay, and Ms. Borsick, do you agree that he nevertheless continues to be required to report as a sex offender?
I don't know, Your Honor.
Okay. All right, let me just hear, and you oppose this, Mr. Daly?
Your Honor, I do oppose it. And Ms. Borsick, because I don't have access to Odyssey since I got asked to do this morning, my main concern in ending it is I do see, although it's not letting me open the documents because Odyssey's not working, but I do see that there was a probation warrant issued in 2015, a revocation order that was issued on November 9th, 2015, and then another probation warrant issued in February 16th of 2016. And I wish I knew what all that entailed because I think that would be relevant, but I can't access the documents and I've been trying all morning. So
there was a probation revocation. It was found to be without merit, and he was reinstated on probation. It was, I can speak to it if anybody needs to know about it. I handled it.
I'd like to.
Yes, the matter was, Mr. Daly, you told me it was 5 years ago, 2015 perhaps.
Yeah.
It resulted, or it emanated from a self-report from Mr. Jerome. A neighborhood teen came to his house who had been locked out of his home and needed assistance getting back into his home. The child came onto Mr. Jerome's front porch, and Mr. Jerome eventually reached out to the child's parents. There was no touching, no attempted touching. Mr. Jerome self-reported that a younger person came to his home, and the probation officer, I think out of an abundance of caution, filed a petition. We had a hearing on it. It was found to be without merit. I handled the hearing. It was dismissed against him. And he was immediately reinstated on probation. I'm entirely unaware of any other revocations. That's I've been handling this matter for a decade.
Okay. Officer Dixon, is that what your records show?
Yes, Your Honor, I'm only showing one revocation, and that was March 8th of 2016. The violation was failure to provide treatment, and he was revoked 3 months with a special condition of deletion of fines and fees, proof of sex offender treatment, and drug and alcohol evaluation within 30 days of release.
Okay, and that was for lack of treatment?
Yes, that was for failure to provide treatment.
I don't think that's accurate. I would know about that, Your Honor. We should look at that, Ms. Dixon. I
You're
don't,
right, Your Honor.
it's not him.
Yes, Your Honor, I'm actually seeing this was, and forgive me, I'm seeing that this was mistakenly placed in the defendant's case. And this is another defendant. I just happened to look at the name.
Thank you, Ms. Dixon.
That
That
is
is
like-
not him.
That is likely than what is showing in Odyssey, as well as a return,
Yes, I just
a
know.
probation warrant that I can't open, so I couldn't confirm.
I
Your Honor,
see.
I'll make this easy for the court. If there was a determination by probation that there was only 6 months left and the state would consent to termination at this point, I mean, there's no point in me arguing over 6 months if that's the point that we're at.
Well, I think he's got 5 years left, but as long as he remains subject to reporting, I'm willing. I mean, he's how old is Mr. Derone, Ms. Borsick?
Mr. Duran, are you about 60? 66?
Yeah.
66 years old, Your Honor.
Okay. As long as he remains subject to, I mean, as long as we're clear that he remains subject to the state law of his sentence, I'm okay with the probation, because I think what he's saying is I don't want to have to take a lie detector test. I don't want to have my picture taken every year. But I do want to make sure that if there is any term of his sentence that means he continues to report, that he continues to report.
Judge, I don't mean to interject, but I think this will probably give the court some, I guess, feeling of support, but the decision as to whether or not the defendant registers is actually made by the Georgia Bureau of Investigations independently of the court, is independent of any court order regarding whether or not the defendant's on probation or whether he's subject to registration. It's my understanding, having been involved in these cases in the past, as well as with the Sex Offender Registry Review Board, that the conviction for which the defendant had pled guilty to or was convicted of does require a lifetime registration.
Okay.
So he will be subject to the Sex Offender Registry until the Georgia Bureau of Investigations determines otherwise.
Okay, thank you, Ms. McCauley. That's all I wanted to know. And that, and we all understand, Ms. Borsick, you and your client understand that, correct? Can't find it.
If he is subject to it, he'll comply with it.
Okay. Anything further on this case? What is the language? I'll suspend or terminate his probation on both these cases.
To terminate.
All right. That's the court. That's what we're going to do today. Okay.
Thank you, Your Honor.
All right.
Thank you. Thank you, Mr. Daly.
All right, Mr. Jerome, thank you. Dr. Osborne, thank you for being on. Is there anyone else on for this particular case?
No, Your Honor.
Okay. All right. Thank you. Thank you, Ms. Borsick. Thank you, Mr.
Thank
Daly.
you. Be well.
Thank you, Your Honor. May I be excused?
Yes, now you may be excused. And thank you, Mr. Daly.
It was good to see you.
Yeah.
Good to see you. Okay. That brings us to Ms. Or excuse me. Yeah, no, to Ms. Gardner. Are we ready to go forward on that? Did Mr. Abadi come?
No, Judge, it appears ADA Grant Rood has joined us on behalf of the state. I just saw him on the screen. I don't know where he went.
I'm here for that case.
Okay, there you go. Sorry, Grant.
Okay, so are, Mr. Rood, are you ready to proceed?
Yes, Your Honor.
All right, then let's just, whoops, let me. Give me 1 second. And we have Ms. Jones? No. That was
Nicole Jones.
Yeah, oh, we have Ms. Jones. Okay. Ms. Jones, you ready to proceed?
I am, Your Honor.
All right. Give me- You ready, Samantha?
Well, I'm sorry, what position did you say this was?
This is 17.
Your Honor, Ms. Gardner is not on here. I'm sorry, I had two going.
All right, this is the state of Georgia versus Samantha Gardner. The case is 20 CP 192128. Today is September the 29th, 2020. I am in courtroom 8A. Our courtroom is open to the public, staffed by a member of the Sheriff's Department. We are also on the court's YouTube live stream channel. Everyone else, except Ms. Gardner, which we'll get to in a moment, everyone else is appearing via the Zoom teleconference platform. I do just want to say that this is an unindicted case. The charges is murder, and therefore this case under the court's policy has to be heard by an elected Superior Court judge. I was the presiding judge the week of June 20, the week that included the July, was the July 4th holiday week. And the day that I was to hear this bond, it came before another judge who stepped in for me. I don't know why Ms. Gardner's case was not heard at that time, but I'm sure we'll hear. Ms. Gardner is represented today by Ms. Nicole Jones, and the state is represented by Grant Rude. Is that how I say it?
Yes, Your Honor.
So first thing that we have to deal with is whether Ms. Gardner waives her appearance for today's calendar. And for this bond argument. Mr. Rude, would you like to ask those questions or would you like me to?
If you could, Your Honor.
Okay. Ms. Jones, your client obviously is not present in the courtroom and she is not present via Zoom. Have you discussed with her waiving her appearance?
I did, Your Honor, and she agreed to waive her appearance for this hearing since it was on short notice.
Okay, now let's break that into 3 parts. Does she waive her appearance does she waive her right to be present in the courtroom?
She waives her right to be present in the courtroom, Your Honor.
Does she waive her ability to be present via Zoom?
She waives her ability to be present during Zoom for this hearing, yes, Your Honor.
And the last thing I heard you say was on such short notice. What does that mean?
It was an assumption of being able to have the case on the calendar and not being able to get it scheduled possibly with the jail itself so she can be present, but she agreed to waive her right so she can have her motion for bond hearing.
And did you speak to her specifically about that?
I've spoken to her several times specifically about that, Your Honor, just recently as of Friday.
So she has waived her right orally to you?
Yes, Your Honor, she has.
Okay. And is there any doubt in your mind that she understood her right and that she wants you to go forward on her behalf today?
There's no doubt that she understood her right and that she did want us to go forward on her behalf today, Your Honor.
All right, Mr. Rude, does that satisfy the state?
Yes, Your Honor.
Ms. Jones, would you like to proceed?
Yes, Your Honor. As it stated before in the motion, she previously had her first appearance May 27th, 2020 for the bond for the possession of firearm or knife during commission of a felony, murder, and aggravated assault. No bond was set when she actually had to have the hearing on June 30th. That was the weekend you were talking about. And at that time, the state stated that they heard jail recordings and was arguing the only issue was about the victim's safety. Unfortunately, I put in the motion Judge Barwick, but it wasn't you. I apologize. It was Judge Lagura had requested the state to provide those recordings to the defense so we can actually go through and hear what was stated. We have reached out to the attorney, which was Mr. Abadi, several times via email, and to this date, we still do not have any of those recordings. However, we did speak to our client regarding the accusations, and the most that her and the co-defendant were talking about are the 2 children that they have together, and just speaking about that. As of today's date, or at least the date of the motion, but today's date, I'm not aware that this case has been indicted by the grand jury. There has been a grand jury set since she has been incarcerated, and this case has not come up for indictment. It has been past the 90 days of confinement. Actually, my understanding, she has been confined now for 122 days, 21, 22, it's over 120 days. And we state that Ms. Gardner is a 29-year-old single female with 2 minor children, one being the age of 6, and the second one is 10 months old. The 6-year-old does have several health issues in which she is needed to help take care of. In fact, at this point in time, he cannot go to school given COVID and everything, because if he gets the slightest cold, it requires for him to be in the hospital for several days on end. The 10-month-old was also, both children were born as a preemie. The 10-month-old also was born as a preemie, and she does have several physical therapy classes that she needs to take. Ms. Gardner has been a resident of the state of Georgia her entire life and has remained in the same county of residency pretty much for her entire life. She is one of 14 children altogether, talking about mixing families, and all of her family, except one who is currently in the Army, resides in the state of Georgia. The family member that's in the Army, he resides in Kentucky. She has been gainfully employed her adult life, and you have in your possession, Your Honor, several letters, character letters about Ms. Gardner's demeanor. You also have a character letter from 2 employers, one actual manager employer, one co-worker that talks about that the crime that happened and that she has been charged with is a heinous crime. However, it was not, she is not the aggressor. It's not her demeanor to be the aggressor on that. Since Ms. Gardner has been incarcerated, she has made it up to the highest level as you basically can, because she can't be a trustee in jail. She has helped other people. She has one other lady that she's teaching how to read that has come into the jail that does not know how to read. She is given counselor of the month, I think like twice at this point in time from the jail. She's been well received because that is truly her demeanor. Other than this heinous crime, she does understand what she has been charged with. She will appear, at every court hearing that this court requires. She appeared at the other ones. And again, the only reason why she is not at this one dealt with making a scheduling with the jail, but she will appear in person or on Zoom if we get back to in-person hearings. At each court hearing, she will be able to attempt to find a job. She did have a job prior to being incarcerated, but again, it's been 120 days. She is very much employable, but I cannot say that she has a job 100% waiting for her when she gets out. As for a risk or a danger to the victims, prior to this incident, Ms. Gardner did not have a personal relationship with the victims. She was not attempting to contact the victims prior to this incident. And during the time when she gets out, she obviously will not contact the victims. The point of the parties meeting up had nothing to do with Ms. Gardner had everything to do with the male that was actually driving the vehicle. Ms. Gardner was always the passenger in the vehicle. The victims was not going to meet up, was not going to talk to Ms. Gardner. They were actually there for the male that is the co-defendant in this case, Your Honor. And just to let this court know, I have reviewed the security video of the day in question. And in that security video, if, once we get to that point, you will see that Ms. Gardner is not the aggressor or the violent person as these charges are made out to. And there will be, there is some defenses or anything, as you would say. So we don't feel that the victims will be in danger. She does not have a way to contact the victims, will not contact the victims. She has, after that last bond hearing, even though she has 2 minor children with the co-defendant, she has cut off communication with the co-defendant and understanding that that is not the best interest for her. And she thought she was just trying to keep up with telling him how much she knows about the children since he can't get in touch with the children. But she also will not be talking to the co-defendant to make any changes or change anything. She has attempted to reach out to assist in any matter on this case and has been left open to trying to talk to the DA and the police officers about what's happened, because she is very remorseful for what has happened, but the things that happened were not done by her own hand, Your Honor.
Let me ask you, would you mind going over again, Ms. Jones, what is your assertion with regard to the grand jury? So this incident goes back to May?
Yes, ma'am. This incident goes back to May. This case has not been presented in front of the grand jury. And I do understand that since COVID, grand jury has not been held and there's been a stay of grand jury hearings. But my understanding, there has been a grand jury hearing since this time where a grand jury was reconvened, and there has been some indictments on cases, but this case was not presented at that time.
Okay, so you're saying since May, we've had a grand jury in session?
My understanding, yes, Your Honor.
Okay. All right, anything further before I hear from the state? I do have several letters that I was sent them yesterday, which I have reviewed. And I believe there are people on the line, are there, Ms. Jones?
Yes, Your Honor, there are several family members on the line who also wrote a letter. Shantoria Gunn, and I think Moya is also on the line, who wrote a letter to you on her behalf, Your Honor.
Okay. Okay. Mr. Root?
Yes, thank you, Your Honor. And first, want to address the grand jury issue. As far as I'm aware of, there's been no impaneling or holding of grand juries within Fulton County. So this case could not have been presented to the grand jury because there is no grand jury. This case, due to the murder charges, is one that has to be presented to the grand jury. So even if Ms. Jones were to waive indictment, that wouldn't be legal. Second, as to the jail calls, I do believe that the jail calls issue were brought up at the last hearing in front of Judge LaGrua, and my colleague Adam Abadi asserted at that hearing that the content of those calls was between Ms. Martin and the co-defendant, Antonio, who was also in custody, and that they were using a third party on the outside to talk about the case, and he was encouraging her not to talk to police. I'm not aware if those communications have ceased or not. I just know that at the last hearing, that was the assertion. I don't know about any promise to turn over the jail calls. I've been texting with Mr. Abadi, and he said he didn't promise that, but we can make those available if your Honor wants us to. And as to the facts of this case, I'll go briefly over them. Ms. Martin and her then boyfriend went over to a gas station to exchange some stuff with the co-defendant's ex-girlfriend. There, an argument proceeded in the parking lot, and according to the witnesses, there was no hint of violence or form of violence as to Miss Martin and her male co-defendant from the victims in this case. And it was Miss Martin who, without provocation, handed the gun to the male co-defendant. He then shot the deceased victim and then got out and shot the surviving victim as well. So this is a party to a crime case. Miss Martin did not remain at the scene. She did not turn herself in. So that's just a brief factual overview of the case so that Your Honor's familiar with the events. And as to the bond, we believe that, in this case that Your Honor should deny bond, that no bond is appropriate in this case. Her willingness to hand over a gun during a verbal argument when there's no reason and there's no hint of violence from the victims in this case shows a willingness to do violence, and we believe that she is a risk of violence in the greater community as a whole. Additionally, her communicating about the case on the jail calls to the co-defendant, we believe shows a willingness to obstruct justice. So for those reasons, we believe that Your Honor should deny bond and keep her on a no bond status pending grand jury and pending trial. Additionally, Judge LaGrua did deny bond according to Odyssey in this case. And we believe that, there have been no significant changes in the situation. The only thing that has delayed indictment of this case really is the ongoing COVID epidemic. Thank you, Your Honor.
All right, Ms. Jones, a couple of questions and then I'll let you respond. I also would like to hear if Ms. White is still on the line, whether she has had, well, let me ask that first. Ms. White, have you had any contact with the victim so one victim died, one victim survived?
Yes, Your Honor, and the victim's family is on the line, the Jefferson family. Yes.
And that was going to be my next call. Ms. White, have you had contact with the victims or the surviving victim, the victim's families?
No, Your Honor, I have not. The unindicted homicide cases belong to an unindicted advocate, Ms. Dilma Dos Reyes. She was on the line earlier. I think she has had contact because I notified her of this. And I believe that's why the family can be present. She notified them, but I have not had personal contact.
Okay.
Okay. Your Honor?
Yes.
Yes, I have been in contact with the family. They are on the line today.
Okay, and can you either summarize or can we get them to state their position with regard to release?
Yes, I have Miss Aisha Jefferson. She is the sister of the victim. And I have Anala Jefferson, Cheryl Jefferson, Justin Burks, Kenyatta Jefferson.
Okay, now are these relatives of the victim who did not survive?
Yes.
All right. Well, would anyone like to speak, just maybe one person?
Yes.
As to only the issue of the defendant's release?
Yes. Miss Aisha Jefferson like to address the court.
Ms. Jefferson, and if you'll tell me how you're related to the victim, alleged victim?
She is the sister.
Okay, is she able to speak?
Hi, yes. Can you hear me?
Yes, I can.
Okay, hi, Your Honor.
I can hear you.
Can you hear me better now?
Yeah, I can hear you.
Okay. Hi, Your Honor. My name is Aisha Jefferson. I'm the middle sister of both victims, Fatima Jefferson and Shadia Melton. We have the same mother and father. I wrote you just a letter to I don't even think the words do it justice, but good morning, Your Honor. My name is Aisha Jefferson, and I'm the middle sister to Fatima and Shadia. My mother, Cheryl Jefferson, and Frederick Melton poured so much love into my sisters so that they become productive, is successful and loving in this world. My sister Shadia was snatched from us, leaving us in disbelief and unbelievable grief every hour that passes since May 22nd.
Ms. Jefferson, I am so sorry. And I understand how you, well, maybe I don't understand how you feel. But what I'm doing today, I want you to understand, is simply related to a pretrial bond. And this lady is presumed innocent under the law. So what I need you to concentrate on, if you could just address this one thing, is whether you or your family has any independent reason to be concerned about her getting out.
Absolutely, Your Honor.
How bad you feel, because I know you feel bad, and I'm so sorry. But if you could just address that one issue.
Your Honor, it wouldn't be justice if someone that is involved in something or attached to a crime as heinous as this, and to get out 120 days later. Anyone involved with a situation like this should go through the process and to see what actually happened. And I think that the evidence will be able to show.
Okay.
We do fear. We do have fear, and we never expected anything like this to happen. But just to know that these two are communicating with each other and attempting to obstruct the case, it's unacceptable.
Okay, now let me get back to Ms. Jones on a couple of things. Ms. Jones, and then I'm going to let you speak. And Ms. Jefferson, thank you very much. I did not. I hope you don't feel like I cut you off. I've got a limited issue that I'm looking at here, and I appreciate you being helpful on that. Thank you so much.
My pleasure. Thank you for the opportunity to address you.
Thank you. And I do realize that there are other family members. I see Ms. Fatima Jefferson, and then there were some Ms. Anila Jefferson, and I wanted to recognize y'all and thank you for being on the call. So please accept that. I want to thank you for being present today, and I am very sorry for your loss. Now, Ms. Jones, getting back to you, did Mr. Abadi tell you he would send you the jail calls?
Not only did Mr. Abadi say he was going to send the jail calls, Judge LaGrua told him to send the jail calls and told us to come back in front when we had those jail calls. And I sent an email, co-counsel sent an email, I called Mr. Abadi, and I've not had a response yet, or even an email saying, I'm not going to send it to you.
Okay, so that's one thing. The second thing is, what was your understanding of, are you on the grand jury thing, are you just saying you think you heard that one was impaneled? Because I'm in this building almost every day, and I don't know of any grand jury meeting for anything.
I'm saying I heard one. That's why I say it's my understanding, and I'm not going out saying as an officer 100% of the court. This case happened right before the police officer shooting at the Wendy's. And my understanding is the grand jury was specially set, and he was indicted from that case. And so that means that was my understanding. It could be incorrect. That's why I said if something happened, there was a time where they re-impaneled one to actually have a case. So that's why I kept saying my understanding, and I'm not. I mean, if Mr. Rode or you guys said that it's not, then, obviously I take who's there, who knows, answer for what happened.
Okay, I will tell you that to my knowledge, there was not a grand jury in that case. I understand it got a lot of press attention, and there were charges, and the court did hear that as a bond matter. But I'm going to take Mr. Rude and any other member who would like to speak up, but I know of no grand jury, and therefore I do not believe any 90-day provision has been triggered.
Your Honor, I'm going to interject and support the court's position. There has been absolutely no grand jury impaneled, and I don't know why counsel would rely on rumors. It's definitively, the information is available that no grand jury has been impaneled, which is also consistent with the judicial emergency orders that have been continuously issued by Justice Melton. I believe the first reference to re-impaneling grand juries came with the most recent order on September 13th.
Okay, thank you. And Ms. Jones and Ms. Hayes, that was Ms. McCauley with the District Attorney's Office who just spoke. So I just want to be clear that from the court's perspective, there is no 90-day provision running. But we still hear bonds, and we are very committed to hearing bonds, and we understand that the conditions are such that we need to be continuing to hear these. You know, I have received and have read material sent on your client's behalf. And so I'm in possession of that. And again, we are more than happy to continue to consider pretrial freedom. Now, did Judge LaGrua actually deny her bond?
The initial case, she denied the bond on the communication in which she said, give us the actual recordings and then we can come back when we talked about it. And there's some facts that was presented to you, Your Honor, that I would like to correct if you want me to continue on and talk about that without interrupting your questions.
No, that was it. I just wanted to make sure that what I'm actually hearing is a motion for reconsideration.
Okay.
Is that fair?
That's fair. That's fine, Your Honor. And since that date, we haven't had those recordings. But what was presented by the ADA, and I understand that he's stepping in for someone else, is not an accurate representation of the facts that happened. Again, like I said, there is a surveillance video in which we've had the opportunity of getting. And in that surveillance video, what was correct was the male co-defendant showed up to meet with one of the victims. Now, until today, we did not know that one of the victims was actually an ex-girlfriend of the co-defendant, if she is an ex-girlfriend. Samantha did get out the car to speak to the co-defendant, and apparently there was a verbal altercation coming from the victim's vehicle. Samantha goes back, boyfriend takes her back to the vehicle, and she's going back to the vehicle. The victims in their car starts cussing, going at, keeping on with this verbal altercation. The victims still in their car drive over to where Samantha and the co-defendant is and blocks Samantha and the co-defendant in the parking spot, is going off, yelling, cussing, going back and forth. It's a parking lot, driving back and forth, still doing an verbal altercation. At one point in time in the video, you will see the male co-defendant slam Samantha up against the vehicle, basically punch Samantha in the shoulder and throw her into the vehicle after she got out because the victims is still yelling and cussing. You will also see the victims who were in their car driving to block them in, yelling and cussing. The driver gets out of the vehicle and is so angry, she doesn't put the car in park. So you see the car rolling backwards, she put it in reverse by accident, and going after them. Where you get the shooting, the victims then, other than leaving the parking lot, go and park their car in a parking spot. Samantha and the co-defendant is blocked in because they're right there where the cars come in. The one victim comes over to the car on the driver's side, opens up the door, starts beating on the male co-defendant. You can see them fighting. You see them getting in an altercation. You see the second victim come out and go on Samantha's side, who is the passenger. She's yelling at them. Then you also see a male step out the vehicle, walk out, shoots one, and then shoots the other one that was on Samantha's side. At all times, you see Samantha still sitting in the vehicle, those two attempting to leave the parking lot prior to all this happened. And you will see that she was as I said, the passenger when the car arrived, she was the passenger when left after getting slammed up against the car, getting beat by the co-defendant and being thrown back in the vehicle. So what ADA Rod is saying, there was an aggression. I agree that there was an altercation on a verbal altercation that did escalate to this. But the beauty of being, unfortunately, 2020 is that there is a video that actually shows all the actions other than seeing inside the vehicle. Now, the whole statement of that Miss Gardner gave him the gun, we contest is not an accurate statement at all. And also the understanding the sister that passed away is the sister that was on the victim that passed away was the victim that was on Samantha's side of the vehicle that would have been able to see in. The other victim was the one that opened up the car door and was beating on the male co-defendant. So we don't feel that prior to this, Miss Gardner did not know the defendants. I mean, not the defendants. Miss Gardner did not know the victims. Miss Gardner has not reached out to the victims. The statement of the co-defendant telling her to be quiet, not talking, I would say he can say whatever he wants to say, but as the attorneys, we have done everything to reach out to the ADA to discuss this case. I even reached out to Mr. Pauston because we thought he was going to be the ADA. We've reached out to the police officer to discuss this case, to see what the police officers needed and to resolve and try to move the case forward. And that's been on the wish for Miss Gardner to attempt to resolve or see what happens, to show them what we have and to see what they have. There hasn't been a time at all for Miss Gardner to abscond or to not work with the prosecutor. It may have been may be in the best interest of the co-defendant, but that's not in her best interest, and that's not what she's trying to hide. And when you say, or he says, she left the scene, again, she was not the driver of the vehicle. She was not in control of everything that happened. So as a passenger, yes, the vehicle did leave the scene. Yes, things weren't going back on. And it is really an unfortunate series of events. And even with Miss Gardner, it's an example of unfortunately being with the wrong person and what things popped off. We don't know, in all honesty, how it got to where it is.
Here's my concern, and I've got concerns both ways. I mean, one concern is that I'm distressed, and I know Mr. Abadi, and I also know that everybody's having difficulty not being in the office, working remotely. There have been some very unusual challenges, and I'm obviously sorry for that. And I'm not saying that he's done anything. However, it is frustrating that the evidence being talked about is in the possession of the state, and there's no incentive. As long as we keep denying this bond, there is no incentive for the state to produce that material. So right now, I'm telling you that I need these jail calls given to Ms. Jones. And Mr. Rood, you're the one I've got in front of me. So I'm putting the burden on you to get these to her, and to get these to her by, you give me a reasonable time, October the 15th.
That works, Your Honor. So what I can do is, if Ms. Jones.
Mr. Abadi, somebody pick up the phone and tell Mr. Abadi, I need the jail calls in Ms. Jones' hand by no later than October the 15th.
That's not a problem, Your Honor. If Ms. Jones and I believe Code of Counsel, Ms. Hayes, can text me here with their email so I can follow up with them. I'll send them the most relevant call so that they don't have to listen to, 1,000 calls or whatever it is.
Now, here's my problem on the other hand. So I've addressed one problem, which is, don't keep talking about evidence you won't turn over to the other side. That is fundamentally unfair, even during a pandemic. But the problem is the Ayala fact. And one of those factors is, of course, the risk of intimidating witnesses. I've already heard that there was a fight. And not only was there a fight, but it was in part the defendant, Ms. Gardner, as the aggressor. That doesn't determine the ultimate issue. I'm not suggesting in any way, shape, or form that it does. She is presumed innocent. She's presumed innocent by this court. But at this point, she would not pass that particular Ayala factor, and so bond is denied. I will take up any reconsideration at the appropriate time if something comes up. Is there anything else on this calendar today?
None for us, Your Honor.
Okay, we'll get an order entered. And if there is nothing further, I'm going to excuse everybody and thank y'all very much.
Thank you, Your Honor.